The merger guidelines. The 2023 merger guidelines were jointly released by the U.S. Department of Justice and the Federal Trade Commission. These merger guidelines outline the factors and frameworks that these agencies use when reviewing mergers and acquisitions. They include concepts regarding market definition and structural presumptions, and are meant to give would-be merging firms some guidance over whether the government will likely seek to enjoin a proposed merger. So these guidelines provide insights into how agencies identify potentially illegal mergers and how they help the public, business community practitioners, and courts understand their investigative process. The merger guidelines are best understood as a way to see how the agencies will think and how those thoughts have changed over time. There used to be different guidance documents, one for horizontal mergers, meaning mergers between competitors who sell the similar products at the same stage of the supply chain, and a different one for vertical mergers, meaning mergers between companies at different stages of the supply chain. But the two have been smushed together into a single merger guidelines. It's still intellectually useful to unpack and think about how these standards might be different for two different types of mergers, so I'll talk about horizontal and vertical mergers as guidelines, even though the guidance has been updated to put them in one document. The horizontal merger guidelines were issued by the U.S. Department of Justice Antitrust Division and the Federal Trade Commission to provide guidance on how agencies analyze the potential anti-competitive effects of mergers between competitors, horizontal mergers between competitors. These guidelines caution that merger analysis does not consist of uniform application of a single methodology. It's a fact-specific process through which the FTC applies a range of analytical tools to what are reasonably available and reliable evidence. The merger guidelines clearly state that mergers are evaluated under a rule of reason analysis, not a per se analysis. We give the merging parties the benefit of the doubt. The 2023 merger guidelines superseded the 2010 horizontal merger guidelines with a notably lower threshold for structural presumptions of anti-competitive mergers, and thus we see an increase in the agency's intended scope in their own merger control. The 2020 vertical merger guidelines, which have now been replaced by the 2023 merger guidelines, themselves replaced the 1984 non-horizontal merger guidelines. The 2020 guidelines recognize various pro-competitive benefits of vertical mergers. That is, mergers between upstream suppliers and downstream consumers tend to have significant synergies and fewer anti-competitive problems. The 2023 merger guidelines, which supplant the 2020 vertical merger guidelines, take a much more aggressive approach to merger control. The 2023 merger guidelines reflect the agency's position that, absent countervailing evidence, a vertical merger is anti-competitive, where a firm will end up holding more than 50% market share for a product, service, or route to market that rivals use to compete. Once again, we see how the antitrust agencies are taking much more aggressive approaches to merger control. The concepts of separate horizontal and vertical merger guidelines has been supplemented by a singular merger guideline that takes a more aggressive approach by prohibiting both horizontal and vertical mergers under a wider range of circumstances, showing the FTC and DOJ engaging in activism to try to limit merger activity in America today.